Hey, Anacleto Alanis III was born to Mario Alanis and Jermila Ballaho, the name on his birth certificate being Anacleto Ballaho Alanis III. He filed a petition to change his name to Abdul Hamid Ballaho, as according to him, he has been using this name since childhood and in his school records. He also testified that his parents separated when he was 5 years old. His mother testified that she single-handedly raised him and his siblings. Anacleto claimed that his requested change would avoid confusion. RTC acknowledged that confusion could indeed arise. However, it stated that granting the petition could create even more confusion, as such would trigger much deeper inquiries regarding his parentage and/or paternity, bearing in mind that he is the legitimate eldest child of the spouses Mario and Jermilo. RTC went on to state that Anacleto should have had the other private and public records corrected instead to conform to his true and correct first and last names. Before we continue, let's acknowledge that our eyes are the window to the wonders of the world. Hence, we don't let exposure to the sun or screens dim our outlook. Let's focus on protecting our eye health and maintaining our vision with proper nutrition. Set our sights on the important nutrients found in USANA Vision X. More about this product on the link found in the description of this video, and you can visit our website or DM us to order. Now, on with the case. It is worth noting that Anacleto filed a petition for certiorari under Rule 65 before the CA after RTC denied his record and notice of appeal for failure to show any reason to relax or disregard the technical rules of procedure. It noted that the trial court did not gravely err in denying his record of appeal, which was filed out of time. OSG, for its comment, argued that the petition must be dismissed outright for being the wrong remedy, and that the proper course was to file a petition for review on certiorari under Rule 45. Should the petition for certiorari be dismissed because Anacleto did not even attempt to show any grave abuse of discretion on the part of the CA? Yes. However, in the exercise of its equity jurisdiction, the court should choose to apply procedural rules more liberally to promote social justice. Thus, in this case, the court delved into the substantial issues raised by Anacleto. But let's look at the reasons why the petition for certiorari should be dismissed. According to the court, number one, the failure of Anacleto to show any grave abuse of discretion on the part of the CA, and on this ground alone, the petition could have been dismissed. Number two, the court could not sidestep the rule on reglementary periods except in the most meritorious cases. Next question. Does the failure to file an appeal due to the inattention on the part of Anacleto's counsel constitute excusable negligence? No. Quoting Sublime versus NLRC, the court said that the unbroken seal of judicial dicta is that clients are bound by the action of the counsel in the conduct of their case. Otherwise, if the lawyer's mistake or negligence was admitted as a reason for the opening of a case, there would be no end to litigation so long as counsel had not been sufficiently diligent or experienced or learned. Do legitimate children have the right to use their mother's surname as theirs? Yes. The fundamental equality of women and men before the law shall be ensured by the state as guaranteed by number one, the Constitution, number two, a statute, and number three, an international convention to which the Philippines is a party. Number one, Article 2, Section 14 of the Constitution reiterated the state's commitment to ensure gender equality. To quote, the state recognizes the role of women in nation building and shall ensure the fundamental equality before the law of women and men. Before we proceed to number two, let us ask, how is Article 2, Section 14 different from the widely invoked equal protection and due process clauses under the Bill of Rights? Answer. Article 2, Section 14 provides a more active application than the passive orientation that Article 3, Section 1 does. Equal protection within the context of Article 3, Section 1 only provides that any legal burden or benefit that is given to men must also be given to women. It does not require the state to actively pursue affirmative ways and means to battle the patriarchy. Article 2, Section 14 implies the state's positive duty to actively dismantle the existing patriarchy by addressing the culture that supports it. Now, number 2. RA 7192, or the Women in Development and Nation Building Act, lays down the steps the government would take to attain this policy. Number 1. A substantial portion of official development assistance funds be set aside and utilized by the agencies concerned to support programs and activities for women. 2. All government departments ensure that women benefit equally and participate directly in the development programs and projects. And 3. Government departments and agencies review and revise all their regulations, circulars, issuances, and procedures to remove gender bias therein. Finally, as a signatory to the Convention on the Elimination of All Forms of Discrimination against Women, the Philippines bound itself to the following. Article 2F, to take all appropriate measures, including legislation, to modify or abolish existing laws, regulations, and practices which constitute discrimination against women. Article 5A, to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or the superiority of either of the sexes or on stereotyped roles for men and women. Thus, the RTC gravely erred when it held that legitimate children have the right to bear the surnames of the father and the mother in conformity with the provisions of the Civil Code and surnames, and it is so provided by law that legitimate and legitimated children shall principally use the surname of the father. The treatment by the RDC of Article 174 of the Family Code and Article 364 of the Civil Code is incorrect. The term principally used in Article 364 does not mean exclusively. This gives ample room to incorporate into Article 364 the state policy of ensuring the fundamental equality of women and men before the law, and no discernible reason to ignore it. Now, what are the other considerations that may warrant the grant of a petitioner for change of name? Number 1, when the name is ridiculous, tainted with dishonor, or extremely difficult to write or pronounce. Number 2, when the request for change is a consequence of a change of status, such as when a natural child is acknowledged or legitimated. And number 3, when the change is necessary to avoid confusion. May Anacleto also change his first name to Abdul Hamid? Yes. The instances recognized under jurisprudence as sufficient to warrant a change of name are the following. A. When the name is ridiculous, dishonorable, or extremely difficult to pronounce. B. When the change results as a legal consequence of legitimation or adoption. C. When the change will avoid confusion. D. When one has continuously used and been known since childhood by a Filipino name and was unaware of former alienage. E. When a change is based on a sincere desire to adopt a Filipino name to erase signs of former alienage, all in good faith and without prejudice to anybody. And F. When the surname causes embarrassment and there is no showing that the desired change of name was for a fraudulent purpose or the change of name would prejudice public interest. The purpose of the law in allowing change of name as contemplated by the provisions of Rule 103 of the Rules of Court is to give a person an opportunity to improve his personality and to provide for his best interest. In the present case, there is ample justification to grant fully his petition, which is not whimsical, but on the contrary is based on a solid and reasonable ground, i.e., to avoid confusion. Is the best evidence available required in granting or denying petitions for change of name? No. The evidence presented need only be satisfying to the court. It need not be the best evidence available. The matter of denying or granting petitions for change of name and the corollary issue of what is a proper and reasonable cause rests on the sound discretion of the court. What is involved in special proceedings for change of name is not a mere matter of allowance or disallowance of the petition, but a judicious evaluation of the sufficiency and propriety of the justifications advanced in support thereof, mindful of the consequent results in the event of its grant and the sole prerogative for making such determination being lodged in the courts.